Hey, my name's Trey Porter. I'm a DWI lawyer in Texas. My firm has been working DWI cases in Comal County, specifically in New Braunfels, for years. I've personally been working in that courthouse handling DWI cases on regular dockets for over 10 years. And both of the attorneys in the firm here each have over a decade of experience themselves. So New Braunfels is some place that we're very familiar with. And it's a place that we stand up for citizens that are charged with DWI. Nothing is going to happen at your first court date for a DWI in New Braunfels. Now, it's going to take a long time to get there. The courts are backed up, they're slow, forensic evidence takes a long time. The district attorney's office is notoriously backed up with their dockets, whether it's at the felony level or in a county court on a DWI case. But on that first court date, whenever you get there, it's not going to be a situation where the judge is asking you questions. You have to talk to prosecutors about anything in your personal life or what happened on that date. Most often, it's going to be a situation where you show up, and again, you comply with the conditions of bond by availing yourself to the court, being on time, letting the bailiff and or the judge know that you're there, and then your counsel, your defense attorneys, will have an opportunity to confer with the prosecutors. When we're doing it, we're conferring with the prosecutors about the exhaustive requests for discovery, for evidence that we filed pursuant to everybody's constitutional rights, as well as the Code of Criminal Procedure, the things that are highlighted that everybody is entitled to when they're being prosecuted. So we're checking in on, hey, where's the video? Hey, what's going on with the toxicology? Hey, we heard this officer got in trouble because they didn't follow protocol. Aren't we supposed to get a memorandum about that? What about that? What's going on with this? The law says the prosecutors have to comply with those requests, but they don't have to do it by the first court date. So the first court date is pretty much just a hurry up and wait. Typically, you're going to be out of there by lunch and on to the next setting a month or two down the road. Penalties for DWI in Comal County are tough. They're consistent with Texas law, which says that if you're a Class B misdemeanor, which is a BAC of 0.14 or lower, then you can face up to 6 months in jail. If you have a BAC of 0.15 or higher, even on a DWI first, then you're facing up to 1 year in jail. Now, probation is available as well. So you can get the probation for that same period of time, 6 months, 1 year. You can get it up to 2 years. And then while you're on probation, the judge can require you to do things and to not do things. So some of the things they can require you to do are go to classes, go to counseling, blow into an ignition interlock device for some period of time. They can require you to do community service. They can also prohibit you from doing other things like drinking alcohol. Even if you're 21 years old or older, a judge can say you can't drink alcohol while you're on probation. And I'm going to require you to go do drug testing at random intervals just so we can check to see that you're not doing that. That's one of those prohibitions and requirements that a judge can do. A judge can prohibit you from leaving the state. A judge can say, listen, you can't leave the county. If you want to leave the county, I'll let you, but you got to get permission. But you can't leave the state of Texas. There are other things that can come in. Judges have almost total discretion with what they can do. The one thing I want to tell you about New Braunfels is one of the things that we see is those things are typically doled out with a heavier hand than they are down the street in Austin, down the street in San Antonio, or elsewhere. Some of that has to do with the judges' personalities and experience. Some of that has to do with the aggressive, hard approach that the district attorney's office takes in New Braunfels. You can get your DWI case dismissed in Comal County. There are a couple ways that you can obtain a dismissal in a DWI case. Number one is you can fight. And everybody needs to fight because the other option I'm going to cover is always going to be available. But everybody needs to fight. And what do I mean by fighting? I'm not trying to be hyperbolic or talk tough. What I'm saying is you need to challenge those charges. You need to assert constitutional rights. And what does that really look like in a DWI case? It looks like holding the burden to their government of proof, which is just the rules that we're all playing by. If the officer says that you broke a traffic law and that's why he or she pulled you over, well, then you need to review the video evidence to make sure that that happens. I can tell you as someone who watches hundreds of DWI videos a year, a lot of times police officers are wrong about the reason they pulled somebody over. And the law says is that if the stop is wrong, everything beyond the stop can be suppressed, which means thrown out. So that's one of the ways to fight. Another way to fight is to look at the forensic evidence. Let's say that the field sobriety tests don't really show anything because you didn't participate in them, right? You just got out of your car and you stood there. And so the crux of the state's case against you is some forensic number. And you don't know if there was a problem in arriving at that forensic number if you don't have your attorneys delve into it. So it's important to get discovery and get evidence about those things and look into the individuals that are actually performing those tests and then doing that analysis and then giving those answers to the prosecutors to use against you. If there are problems with them, there could be problems with the evidence itself. So those are some ways to fight on a DWI case that can get you a dismissal. The other way to get a dismissal is to go through those, analysis, run those traps, and if nothing hits, if everything looks to be in almost perfect order from the government, which sometimes is the case, then you can still sometimes get to a dismissal through negotiation. This is where relationships come in. This is where it's important to have somebody on your side that knows the players in the courthouse, because knowing who to ask, knowing how to ask, and knowing what you might need to have in your folio right after you do ask to show them why you're asking and bolster your chances and give you some momentum, that can be a way to get to a dismissal through what's called deferred adjudication. Now, deferred adjudication, you still have to do probation. So it's not an easy road to get there, but there is a carrot at the end of the stick. You're not just doing probation because the judge was nice enough not to send you to jail. You have a contract for dismissal, and if you hold up your end of the bargain, they'll hold up their end of the bargain. So those are a couple ways to get a dismissal: fighting or deferred adjudication. The third and final way is to take it to the people. You can always have a jury trial. All of us have a constitutional right to a jury trial. And so if you run the traps on the evidence and there are issues there, but it's not enough to convince a judge to do a dismissal, if you run the traps on negotiations and maybe you can get deferred, but you just don't like the way it is, then you can always request a trial. Now, a trial gives you your greatest relief in that if you win, you walk out of there and you win, it's over. But if you lose, then you've got a jury of your peers who drive the same roads that you drive, and they go to the same places that you go to, and so do their family members. And in a conservative jurisdiction like Comal County, that's something to be considered, which statistically is why you just don't see a lot of DWI trials. A lot of people try to avoid them. I'm here to tell you, we never run from a trial, and sometimes that's the best way to get the best result. No matter what your feelings are on it, it should always be one of the options considered for a DWI dismissal. Your driving privileges are not suspended after a DWI arrest in Comal County. I don't care what the cop told you. I don't care what some guy in the jail told you. When you walk out of the jail on bond, your driving privileges are 100%. Now, they are subject to an automatic suspension from Texas DPS, and that suspension is set to go into effect in approximately 40 days. Somebody should have given you a piece of paper that says this. If they didn't, it doesn't matter. It's still happening. What can you do about it? You have a 15-day window, and that clock starts ticking on the calendar day that you were arrested. You have a 15-day window to request what's called an ALR hearing. The program that DPS suspends your driving privileges through is ALR. It's an administrative license revocation. So you can request a hearing, but the request has got to be put in within 15 days. If you do it on the 16th day, they won't give it to you. If you put the request in within 15 days, it pauses everything. That suspension that's waiting for you 40 days down the road, it's not going to happen at the 40-day mark anymore. What's going to happen is you're going to be given a hearing date, and you're not given the hearing date at the moment that you request the hearing. This is a complicated deal. So you got to request the hearing within 15 days. And then at some point later, you're given a hearing date. And whenever that hearing date is, you have an opportunity, or through counsel, right? We do this for every client in every case. You have an opportunity to make the government formalize that suspension. So they have to get their ducks in a row and come to court. It's pretty easy for them to do. It's attorneys from the Department of Public Safety, and they're in front of a judge from guess which agency? The Department of Public Safety. So it's everybody on the same team against you, and all they're doing is checking to make sure a couple things are true. Are you who the cops said you were? Is the situation that occurred something that would yield a position that you were put in to refuse or participate in a breath or blood test? right? Is everything checking out? Is this what it's supposed to be, right? And then above and beyond that, with respect to the big question, did you fail or did you refuse? Is that true? What's the deal with that? That's all they're looking at. The district attorney's office in Comal County is not involved in the ALR hearing, and they can dismiss your DWI case, and DPS is still going to go forward with the hearing based off of the implied consent laws here in Texas. So why do all this stuff? The reason to do it is, number one, it pauses that automatic suspension. Number two, it gives defense counsel an opportunity to get early testimony and early evidence in your DWI case. These things happen faster, especially in New Braunfels, than the actual DWI case in the county court. So you get a little bit more information and you get an idea of what's going on a little bit sooner, which can be helpful. And then finally, because you're forcing the government to formalize everything, you're putting them in the one position you can put them in to drop the ball. And that means that if the attorneys for the Department of Public Safety don't bring the right paperwork or they file something incorrectly, or if the arresting officer or officers that were subpoenaed to the hearing don't show up at the hearing, then you win. You took your only shot and you got it, and you get out of this driver's license suspension, which of course is a big win for practical purposes because we all have to drive everywhere, right? But in addition to that, it helps you on the pocketbook, right? Like you don't have to pay increased insurance charges. It's not going to go on your record as a suspension that would be there forever on your driving record. You don't have to fork out money to get an occupational driver's license, and on and on and on. So it's one of these deals where you have nothing to lose, you have everything to gain. And even though the table is absolutely set against you, I encourage you to do it. Again, we do it for all of our clients. Final piece on this is that let's say that the government does everything right and you do end up with a suspension. Hope is still alive. Texas will take your money for an occupational license right after deciding through a court order that you're too dangerous to drive. So know this, even though it's a complicated process, there's no scenario in the whole process where you can't stay on the road and drive legally no matter what.